on now.
Okay. I'd like to call this workshop to order. It's November 21st, 2019. We'll stand, do a pledge of allegiance, and then we'll start the workshop. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all. Okay, please be seated. Now, we're going to start with the short-term rentals, or are we going to start with the big book?
I didn't anticipate short-term rentals, but, I mean,
It's on the agenda
is it?
for not online, yeah.
Oh.
Because we had said it at the last town board meeting.
Yeah, oh, okay, so,
I'm just trying to understand so the audience
Sure.
knows which one we're doing.
It's on the first page, Russell. On the home page.
Okay, that,
That's
you're
there.
going to talk to this one?
I just wanted to know whatever notes you guys had. I have
Okay,
nothing left to say on it.
but I'm
Yeah,
saying
yeah.
you're running this part.
Sure.
Okay. So at this time, Councilman Dean Whitten will conduct the review and comments relevant to short-term rentals. If anybody has any comments, please step up to the microphone like we always do. Name, phone, address, and discuss with us, not the audience. And we'll proceed on through, essentially page by page or something.
Assumed you were going to have some.
Oh, yes. You don't think I would forget you.
Well, Mr. Dodd.
If I could have a comment first, Russ Tompkins, if you look on the revisions for zoning, you look at the current one and you look at the revisions, tonight shows, I believe, starting with 64, goes to 66, 68, 70. It says nothing about short-term rentals on there, and I haven't prepared for it, so I think it's misleading. If you look on the website, it specifically says it's going to start with 250-64. And there's nothing at all about short-term rentals.
Yeah, at the last town board meeting, we had decided that we weren't going to discuss the short-term rentals law because we would do it at the zoning revision meeting.
Okay, well, I tried to go on a website, and I know the other night somebody said you can find the short-term rentals and the events on there, and I'm not very good on a computer, but I went through all the different boxes and clicked, and I didn't see anything that I could print off so that I could get a copy of that.
There's a discrepancy because did you go to the actual page with the zoning revisions? You
I went to
clicked
Town of Clinton website,
on- Yeah,
and then you can go over to zoning revisions,
right, okay.
or you can go to topics, you can go to town boards, you can go to agenda meetings.
The agenda is also, I'm not excusing this, but just by way of explanation, the agenda for the meeting is also listed on the main page. Below the photograph, if you scroll down, there's a section that says notes, and there's a list of the items that are being discussed at the zoning revision workshop. And in that section, that's where you would find the short-term rentals thing and also the events thing. So it's on the front page, it's not on the page that you're reviewing.
Well, they said I admit that I'm
So,
very deficient when it comes to computer, but I tried to find it and I couldn't find anything on there, clicking on different boxes.
it should be in both.
And when I did go over to the zoning revision and go down for tonight's meeting,
Not there.
it started with 250-64, and there was no mention of it. I know at the last meeting you said you were going to put off the events, you were going to put off the bed and breakfast, or the events and the short-term rental, and I think you were waiting, the reason you didn't vote for it the other night was because you were waiting for the lawyer's comments on the events.
Right.
Yeah, and on
So-
short-term rentals, we had gotten the attorney's comments, and I had sent that copy to everybody. And so instead of taking the time at the meeting, going page by page with the notes I know I'm going to get, we figured we'd do it
All
at
right,
this meeting.
well,
Well, you can do both. I mean, you can discuss it tonight and then have it on the agenda for the next town
yeah.
board meeting.
Yeah, this pass on the short-term rentals is just draft comments to update it.
It doesn't preclude-
It's no approval, it's not a final document or anything.
Yeah, so it doesn't preclude the public from having comments on it at a later time
Yeah,
as well.
so it's just first pass. That's,
It's a new law.
It's a new
New
law
law.
that we've been working on, so.
it's section 105 of 250, but there's nothing that
It
you're going to
doesn't
find
exist.
anywhere.
Ian, go to the front page. Scroll down below the photograph, you'll see. And you just click it, there it is.
It says this, yeah.
Yeah, it's right there. But it doesn't have a number because it's not a section. It's a standalone.
Yeah. It's one of the special ones that we're doing versus the regular zoning revision.
Okay,
Okay, y'all ready down there? Let's see, get this one
We
here.
might as well start.
Yeah,
Yeah,
okay.
ready to start wherever you are.
Go ahead.
Now, let's start first page.
All right. Seems like a reasonable thing.
Yeah, first page. There's going to be reflections as we go along where I think you need definitions to add here, but I didn't put them in the front page because
Okay.
I didn't know I needed them yet. So that's that one. And the second page, again, there may be some definitions that pop up there that came later in the timing. Now, page 3 is where I get into the thing. The very top paragraph on page 3, this is under, just so people understand, short-term rentals, purpose and objectives. And what it says, all short-term rentals operating in the town shall submit a short-term rental registration form or apply for a short-term rental special use permit as applicable, no later than 6 months from the effective date of this section. My comment is, so if someone does it 8 months after the effective date of this section, they cannot apply. Is that what you mean?
No, it means that after 6 months, they would be operating their short-term rental illegally. They could be cited by the ZA.
Yeah, but the way it says, apply for no later than 6 months, which says, my simple reading says that if you don't apply in 6 months, it says by, that you can't do it again. I know that's not what you really mean, but that's what's written.
How would you change it?
I would not put the 6 months.
Well, I think the intent is that all these are working out of compliance.
Yeah.
So to be in compliance, that you're required to, after the implementation of this law, to apply within 6 months of the law being implemented.
So basically what we're saying is in that first 6 months, you still wouldn't be cited as being out of
Okay,
compliance
so
because
then
you
you
have
c-
6 months to apply.
Okay, so that would be
So-
for existing.
Well, sure.
Well,
Yeah.
but I'm just saying, if you put in existence, existing ones, then
No,
it
what-
It
makes sense.
says operating within the town. It could say existing in the town, I guess, but
What if you added the words "to be in compliance" after section?
after a section.
Or something to that effect. No later than 6 months from the effective date of this section to be in compliance, or something like that.
See what the attorney has to say.
Just a drafting suggestion.
Yeah,
All short-term rentals operating in the town at the time of the adoption of this rule or section shall submit a registration form or apply no later than 6 months from the effective date of this section, and failing that, can no longer operate the short-term rental.
Do
But
me,
my question is the filing of the application?
do me a favor. Introduce
Oh, I'm
who you
sorry,
are.
I'm sorry. Ian Schrank, Fiddler's Bridge Road, Town of Clinton.
Thank you.
But my question is it the mere submission of the application that allows them to continue operating, or does it have to be approved within? I mean, because in other words, if you apply, if you get it in on the day before the 6-month anniversary, you got to give the, I don't know if it's the town board
Yeah,
or the zoning administrator, time to review it and approve it.
Yeah, I think what this is just saying is that you have to apply within 6 months, and in that first 6 months, you won't be considered out of compliance by the ZA, so you can't.
Correct, but at the 6-month, and let's say your application gets in 6 months less a day.
Yeah.
6 months and a day, there's been no approval of the application yet.
Yes, but you've applied,
Yeah, but
you've submitted the
It's the
form.
application. It's submitting the form, that's
so
the
while
issue.
while your application is pending,
can still
you
go.
can still
Yeah.
operate.
That's my
Yeah,
point.
yeah.
Which I think we should say that too, to make it clear that
Yeah.
if you got it in before 6 months, you are in compliance until such time
I
as
see what you're saying,
it's
yeah.
rejected or
Rejected or
something.
approved.
Okay.
So how would you word it?
Well, all short-term rentals operating on the effective date of this section in the town, and shall submit blah, 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 no later than 6 months from the effective date of this section, and failing such submission can no longer operate in the town, period. Operation of such short-term rentals during the pendency of that application is permitted.
I'm gonna have to watch the video later.
I'm happy to give you some words later.
Well, but isn't it implied that if you have an application in pending, that you're allowed to operate until it's,
Probably, I was just trying to
Only
be
if you
clear,
were in
that's all.
existence before something.
Right.
Yeah.
If you're
Otherwise,
operating in the-
I think
everybody
someone
would,
that's new.
a new one. You didn't exist before.
Like after that 6-month period is up, say this has been in effect for a year and a half, you can't start operating an Airbnb before applying.
Right.
You have to apply and get approved first.
Yeah.
all right,
So,
okay, all right,
Just like any other
okay,
permits.
all right.
This is basically grandfathering everyone in
Yeah.
Yeah.
until
Give
the
'em a head
application
start.
is
Yeah.
approved or
Yeah.
disapproved.
yeah.
Okay.
Okay?
Jeff Newman, Route 9G. So this paragraph is intending to apply to those who are legitimately and legally operating, for example, a bed and breakfast, as opposed to somebody who's opened an Airbnb prior to the passage of a short-term rental law.
They're two different things.
Right.
Yeah.
So,
Right,
No.
but this as written would apply to both. If I'm operating an Airbnb currently outside of the law, I would have 6 months to apply
Right.
and still would not be outside compliance, and yet I'm outside compliance. See what I mean?
But this does not apply to B&Bs.
Bed and breakfast establishments are already approved.
Are different.
Someone is like, it's different. It's not in the definitions here because short-term rentals don't apply to them, but,
Okay,
They have a whole section.
right, but you,
right, but that,
didn't you break out more than one room?
yeah, so,
So Airbnbs, even if they have more than one room, currently are still
Oh, yeah, yeah,
Airbnbs.
yeah.
So you are lumping all Airbnbs into
Yeah,
the,
yeah.
I mean, all B&Bs
B&Bs
into
into
this,
it.
if they have more than one room.
I'm just suggesting that it should be more clear that it's split out, that I understand the intent to be.
The zoning officer has stated that Airbnbs are not operating outside law.
yeah, there is
They are now legal.
Okay,
The zoning administrator has determined
Yeah.
that they are an allowed use.
Until
they
this,
currently-
until this law goes into effect, then
Well,
they're,
Until this law
Yeah,
goes
until
into
this goes into effect, the zoning
So-
administrator and our attorney are in agreement that people operating Airbnbs right now are in
Yeah.
compliance.
So
okay,
they're in
interesting. I didn't know that.
compliance. They're
Separate
not out
question,
of
so I won't
compliance.
ask too many questions about
They
that.
won't be
'cause it gets
out
us
of
off topic.
compliance until this law goes, or some law goes through.
Right. So in that case,
Meantime, they're
to raise question, and I agree with Ian, Ian, to just add language of short-term rentals operating in the town prior to effective date of this section shall submit a short-term. I mean, it's a fairly simple way to say, bring yourself into compliance within 6 months.
Yeah,
Yeah.
yeah,
So that would be my recommendation, adding that phrase.
yes.
Okay. Thank you.
Okay, now, this is a minor one. I don't know if the next sentence there, where you have all the town code, Dutchess County, et cetera, I don't know if there's federal. Should we add federal regulations? I don't know. I just,
Yeah, I mean, Shane read through it and didn't add
it's
it.
ignorance on my part, but it's something that maybe
That's all.
Lou knows. I don't know. There may be some subtle thing on federal.
Yeah, I almost feel like that's implied anyway. You gotta comply
Right.
with federal,
That-
all of those.
Yeah, I mean, as they say, it's a small thing,
Yeah.
just wanted to do it. Okay, the next section, short-term rental permitting requirements. It says all type 1 short-term rentals must apply for a short-term rental certificate using the short form
Yeah, it's not here yet.
rental registration form annexed hereto as Appendix A, et cetera, et cetera. My comment is, we do not put the form with this law. The form is separate from the law.
Yeah, so we can just say short-term rental
Right.
registration form, and it doesn't have to be annexed here to
No,
appendix.
and the reason is, and it appears several places,
Because of
is if we ever have to change
Change it.
any line on it, then we gotta have a new
yeah,
law, and
no,
a
I
new
agree.
law costs about $1,500 to approve. I mean, it's just a ballpark. So it's just like when we do the fee schedule. We say reference to the fee schedule, okay? Well, all we do is reference a document. We approve the document separately.
I agree.
So that popped up there. And as I say, I'll mention it several other places as we go. And then down under paragraph 3 with the parens around it, and about halfway through it, the very first word says, within 30 days after receipt of a renewal request, the zoning administrator shall confirm the short-term rental is in compliance with the terms of its short-term rental certificate. One, I don't know if that's too fast to actually do that. If there's a question, for example, say the guy doesn't have the GFIs, which pops up in here, and the electrician's gonna take a month and a half to get there, he's got a problem. He can't prove that it's approved because has an open issue. So I would check with Lou to see if that would be a problem. I'm just looking at it as an operational thing, not as a legal thing.
Yeah.
Just to maybe make it so that it works. Okay.
Ian Schrank again, Fiddler's Bridge, very small comment, but
Yeah.
I think that you should do it. In that sentence you're looking at, Ray,
Yep.
it should be within 30 days after receipt of request, the zoning administrator shall confirm whether the short-term rental is in compliance. I assume that's the intent. If they're not in compliance, that's a problem, right? He's not
Well-
just obligated to confirm they're in compliance.
Yeah.
So I would put the word whether in there, shall confirm whether the short-term rental is in compliance.
Well, but if that's the case, you should actually say that, or else it can't continue. You should say that it's in compliance, because if it's whether, it implies that it could possibly not be in compliance, and then it can't continue.
Well, this is all about renewal, and so you're right, obviously, I read the next
This is
sentence.
renewal, yeah.
This is about renewals. He has the discretion to renew, amend, or deny. So to me, that's where ZA would say, hey, you're out of compliance, I'm not renewing this, or
Yeah.
I'm going to amend it.
Okay.
Okay. Do you have rollers on your chair?
Jeff Newman again. Again, I think the intent is to put a time frame on it so that it doesn't sit on his desk for a long time, right? You want the people to be able to continue to operate. What about that he has 30 days to review it? The next sentence says that he shall have the discretion to renew, amend, or deny the renewal of the special permit rental certificate for good cause shown. But if he has 30 days to review it and comment, or review it and submit a response, as opposed to 30 days to actually renew it. Because if he finds something, like Ray was saying, like, oh, you know what, we want to renew this, but you've put this other coffee pot here, and that's on a GFI outlet, so you got to fix that, they may not have that time.
Yeah.
So just change the words to review.
Confirm to review? You mean?
Discretion to review.
Within 30 days after receipt of a renewal
shall
request, the
review.
zoning administrator shall review the
Shall
short-term
review.
rental is in compliance, shall review the renewal
The
request
renewal,
and make a determination.
or something, yeah. And keep the 30 days, is that what you're saying?
I think 30 days is I mean,
To review it, yeah.
the ZA should weigh in there, but,
Right,
30
right.
days seems pretty reasonable, and, they're submitting it 90 days
Well-
ahead of their expiration date, so it gives him 30 days.
And I
to-
think they're also, when they're submitting the renewal, they're going to be submitting that there have been no changes to the property. And there's not going to be much to review on a lot of them.
Right.
But it's going to check to see if there are complaints against the property or not. And
Okay, thank you.
Page 4, under short-term rental permitting requirement, oops, I went down too far. Okay, well, we'll back up to that when I started here. Little paragraph 2, it's the same comment, not local law.
What are you talking about?
It says annexed here
Oh,
too
annexed
as
here too,
appendix
yeah,
B.
yeah,
It's the
yeah.
same as I
Yeah,
said,
yeah.
they're gonna pop up all over the place. And then on the top of that page 4, a number 4 with braces around it.
At the top of the page? Okay.
Yeah, top of that, it says, an owner of a dwelling or accessory dwelling is restricted to one short-term rental certificate regardless of the number of properties owned. I had a comment on that saying,
Shane's got a comment.
I know he does, his comment's on page 4.
Yeah.
Saying, I think it's not legal. I mean,
Yeah,
we
Shane-
could try it.
Number of
So,
different properties, I guess, is what you're saying, right?
yeah, so
Different
what this
addresses.
was to try and prevent, say, a company from coming in, buying up a bunch of properties and using them all as short-term
Or
rentals.
buying a motel and call each one of them a
Well,
short-term rental.
yeah, but we don't have a motel in town, so
No,
I'm not
but
worried
I'm
about it.
just-
But the comment from the attorney is, this is very restrictive. What is the policy behind this? I am not sure it would withstand a legal challenge. I would strongly consider deleting this provision. Plus, there are ways around this, such as forming multiple LLCs, who owns the property, and then apply. And I mean, I knew that there were ways around it by forming multiple LLCs. Obviously, you know, that it costs a couple $1,000s to do that each time, but, you know, I knew that. I just didn't want to make it easy for someone.
I'm not a legal expert on this particular aspect, so I can only point out there's a question. I can't tell you
Yeah,
what
I
the
mean,
answer
I
is.
still stand by the reasoning why I wanted it in there.
Yeah.
He doesn't think it's legally defensible.
Yeah.
He says he's not sure that it would withstand a legal challenge.
It's under, I think, the arbitrary and capricious definition.
Because we don't, I mean, I know what the argument is. The argument is that we can't limit how many homes a person can purchase in our town, right?
Yep.
So we can't really limit what they do with all of the homes that they purchase in that town as well.
So this falls in the section of type 1, short-term.
Yeah.
The definition of type 1 is owner-occupied.
Yeah, yes.
Yeah.
So therefore, a person, regardless of how many properties they own, can only legally occupy one. So therefore, it becomes a moot point and doesn't need to be included. It could be worded as you know, where there has to be their primary residence. In the definition of type 1, does it have to be occupied as their primary residence, or does it simply have to be occupied by them? And then, which is a whole other thing, by what percentage? If you're a weekender and you're there 3 weekends a year, is that considered occupied?
So you're correct that since this is hosted, this is under type 1, that it could be deleted. But then on page 6, it shows up under type 2 again, which is where it wouldn't.
Yeah, it's a different thing, right?
Yeah, it's a different thing.
Right, right. But it does bring up the question, back to the definition of type 1, is what is the definition of occupied by the owner? Oh, so sorry, it does say during the period which it is rented.
Yeah.
So one person couldn't.
Live in 2 houses.
Exactly.
Easily.
So theoretically, a person could have multiple short-term rental certificates, provided they weren't, for multiple properties, provided they were at that property and only renting one at a time because they were there.
Yeah, they'd have to be there while it was occupied.
Right.
Or the wife lives in one and the husband lives in the other.
Right. All right, thank you.
I don't know. Give it a shot and figure
I
it
mean,
out.
well, I'll delete it from type 1 because it serves no purpose under type 1.
Yeah, okay.
But under type 2, and I'm willing to keep it in, but I want to hear what others have to say.
Okay.
Yeah, it's on page 6 again, under type 2. But we'll go through the rest of 4 and 5 first.
Yeah. Top of page 5, and this is under,
Oh, yeah.
this is a definition of, still under, no, this is type 2 now, short-term rentals, permitting requirements. If the property upon which the dwelling or accessory dwelling unit is located is served by a private septic system, a septic inspection report dated within 90 days of the date of the application stating that the size of the tank and leach, should be leach field or absorption field, or area and location and condition of all septic system components If it's a newly built, I'll say within the last 20 years, we have that information. If you go back earlier than that, most people have no idea where they are.
Well, you have the information stating the size and all that, but not the inspection report from
No.
within the previous 90 days.
No, the point is, you say you want stating the size, tank, leach field and absorption field area and location and condition of all septic system components.
Mhm.
Most people, the best they know is where the tank is. The rest of it, they don't even know.
Yes.
So they could never give you that information.
Well, they could if they get a septic system inspected.
No, they won't. No, you will not see
Yeah,
it.
unless it fields.
Not the field, yeah, not the.
I'm saying it
leach
fields, and the only
Or
way
the
they
D
would know is
boxes.
if it does a dye test and it fails, and the
Yeah.
test,
Yeah, you
the
can
dye
see
comes
that.
up, then you'll know.
But that's, no, but, yeah,
You got a plumber here.
yeah, no, I mean, no. I mean, I've had the county do dye tests
Yeah.
in the past, and some people fail and some people pass. But just to specify that you gotta locate and the
So
condition.
do we even, well, I mean, if we take all of that out, do we even
No.
need the,
Well, you could put the
inspection
size,
report?
they may not even know the size of the tank, because, you know, in the old tanks, they were metal, 500 gallons, and now they're 1,000 gallons concrete for the most part, but some people have them 1,500 gallon tanks.
Chris Giuliano, Center Road. I don't think it should be totally taken out, though. I do agree with the fact of at least having it inspected, because you know what I noticed, being in the business, I guess this is the whole thing. If you tell people like every 3 to 5 years is the rule of thumb to have a septic system pumped on that, most people won't until they have a problem. And then
it
that,
backs up.
as it backs up and it starts pushing out, going to the distribution boxes, into the fields, it does become a problem. So, I mean, if whatever that thing point is, have it inspected and pumped, it would kind of force them, because they're going to have a lot more usage than with a regular house. So the only thing I think is the issue is, again, is trying to find the fields, you know. But if they can prove that it's being tested, at least they're taking the initiative to make sure it's done. I think would be a good happy medium on that.
Because we get, just as a point of information, we get a lot of people that come into the town hall and they say, my toilet's backing up. Where is the septic tank? And I don't know where it is. I don't know all the properties. And it essentially resolves itself if it's like 20 years old or more. There's no record. More currently, when we get building permits out there, the design of the septic systems there, the D boxes, the lines, septic tank and everything else. So you got a fighting chance there. But a home that's 75 years old, they just generated from a outhouse to some septic field of some cesspool or something, and you just don't know.
To Ray's point, that's very, and it may not even be a septic field.
I know.
If it's old enough, it could be a cistern.
Yeah, I know.
Just a leach pit, right? And I like that this is in there, because I think it is really important. We ran into this on our property not too long ago with a corporate event that was there, and they wanted to do increase into like a big one-day event where they brought their investors in, and we had to say no, because it would have gone past what our septic capacity was for that day. But we had the infrastructure to monitor our water usage. Somebody who has a house that's 75 years old has been flushing their own toilets for a long time. And now they do the short-term rental, and they've quadrupled the number of toilet flushes that they're doing, what they're putting into their tank. Their tank might handle it fine, but within 6 months, the leach field or the cistern or whatever it is fails.
Right.
And you won't know that until it fails. I don't know what the answer is, and I don't know if there is a specific septic system report. I know the health department has a SAN 34 for new construction, but I don't know that there's a septic inspection report. And part of that would be something to explore. Does it mean that I could call Royal Flush and say, hey, come out and just write a letter that says my septic was pumped and it's okay? Or is there a specific form you're looking for?
yeah, I mean, this does say, further on, the report must state the septic system was adequately functioning at the time of the inspection.
Right.
You know, we can't predict what's
And,
going to
and
happen
that's
to
the
the
thing you
leach
have to
field in
decide,
6 months,
right?
but
Yeah, at some point, it's a leap of faith, and you say, okay, it's
Yeah.
working.
Yeah.
Great. And then when you come up for review, maybe it's not. But
My
what would
only
you change in it?
Yeah, my only comment is it's that information for where the tank is, location, the leach or absorption field area and all of that, you just don't know. And the condition of all the septic components, you don't know what the D box is or how the lines that run out there.
Yeah, I think the location of the tank, though, if you don't know where it is, then I don't think you should be. You should know where it is.
A lot of people don't. They
There's ways
buy
to
it-
find it.
maybe as a show of good faith, the requirement should be to submit sorry, the words just gave me, plans of your septic system. So if it's new construction, you should have that.
Oh, yeah,
Right,
well,
the
you-
last
Board of
20 years
Health
or so,
needs
right?
that before
And if
they'll
it's
approve
older
it.
than that, to require that they submit a FOIA request through the health department to get whatever plans were on file. Because whenever that property was last sold, going back, I imagine the last, I don't know how many years, several decades at least, that information should be there. But at least they've made the attempt, and you know that it's on their radar to submit a FOIA request. And again, it would be as designed, not necessarily as built. So it still may be incorrect, but it shows that, you know, it's important to the town and that the property owner has taken the steps.
Good point.
Or say where available, information where available.
Or then everybody can opt out and say it's not available.
I know.
Ian Schrank again. Just a suggestion, someone wants to generate revenue and have rental in their home. Why don't you say that it is the burden of the homeowner to come forward with reasonable evidence that their septic system will be adequate for the intended use? I mean, I don't think that's unreasonable.
That's good. The burden then would be on them to find it.
Yeah,
and
it's up to them to
do whatever.
verify it's
have an
there.
inspection or whatever they have to do. They've
Good
got to
point.
come up with reasonable evidence that it's adequate.
Yeah, well, that's right there. It says in the next line, the report must state the septic system was adequately functioning at the time
Well,
of
but that's
inspection.
adequately for its
Functional.
prior use, perhaps.
Yeah.
And we're talking about future use where they're renting out one or two or whatever apartments.
I'm going to have to watch this whole video over again.
Yeah, I mean, I think, you know, an important point also kind of related to this is that there was concern that somebody was advertising their Airbnb as being, let's just say, 4 bedrooms, but the county records shows 3 bedrooms.
And
You know,
that's in
so
here, too.
we're giving a permit, it's based on, you know, 3 bedrooms, not for them to embellish on, saying, yeah, it fits 20 people.
Yeah, and that's in here as well, further on in that paragraph.
But that's really where the septic inspection is gonna come in
Yeah.
and certify that, yeah, we can handle how many people.
I agree.
Yeah, but the only thing is, it says, in the statement, it says, is limited by the number of bedrooms allowed for the size of the septic tank, leach field, et cetera. But there's no reference to the CO, so it should say limited to the number of bedrooms on the CO. Now, I realize there are no COs for houses that are 100 years old and stuff like that, and they'll have to worry about how to deal with that. But it'll put the pressure on.
Yeah.
This is what we want. So you want the CO to recognize the number, and if the CO is predicated on a building permit or whatever, did the guy change something? Because I was talking with somebody the other day where we were casually talking about Airbnbs, and this person bought what's called a railroad house. You know, you have a front door and a back door, and it goes straight through. Well, they took the front room and put a wall in, an extra wall, and put a door on the going into the kitchen area and locked both of those things. So now they had 3 bedrooms for Airbnb. But to get out, you didn't have much choice. You either go out the front door or the back door, and I don't know what the guy in the middle does. Goes out the window. So, I mean, these are kinds of things, and there's been situations where they've done it in the basements. They put little cubes, 10 by 10, rented them out for lots of people. So, I mean, it's important. Yeah. Yeah.
Well, yeah, that's how they get the approval anyway.
Yeah, you got to get up on,
So I've seen it, again, in my business, and unfortunately, going down to the basement a lot, that is a serious issue, safety issues, because
Chris,
there's
mention your
egress.
name.
Oh, Chris Giuliano, Center Road. So, that's a problem. So, I mean, maybe it's shown with the permitted bedrooms within the house and saying, someone may, I mean, obviously it's got to go through the zoning enforcement officer and inspections and stuff like that. Agreed.
okay. We're going to have it.
Just
One,
have a
two,
mic you
three.
guys can pass around.
Yeah, sorry. And isn't it true that any building can apply for a certificate of occupancy even if it's pre-existing, right?
Oh, yeah.
Yeah, so maybe that's a part of it, is that it requires a certificate of occupancy be issued by the building inspector.
But a lot of times, the very old houses in the 90s and stuff, they issued letters from this building inspector saying that since the house has been in existence for 100 years, you're in compliance, and it's a written CO, it's not a formed CO, which is adequate for the insurance companies and stuff like that.
Right, and then it would be up to the building inspector then to accept that and
Well, yeah.
formalize the certificate of occupancy with something current.
I would think that it's within our powers to say, because they're changing the use, that they must comply to current,
Yeah.
building standards with GFI outlets and everything else.
And
Where
egress.
if your house was prior, you didn't need a GFI outlet. I mean, now you're changing the use and you're making a commercial, we should have GFI outlets.
Right, and New York State Code is concerned with familiarity, right? So part of egress has to do with the fact that you live in the house, or are you a lodger in the house? And a lodger in the house is a different thing, because you don't know where the door is.
Right.
There we go.
Yeah. Okay, you got that?
Yeah.
Okay. The next one is sort of the middle of that page, same page. This talks about insurance coverage, liability, et cetera, personal stuff. My only comment was that approved by Salerno, our insurance broker?
I didn't run this past Salerno, no.
Just run it. They'll probably accept it the way it is, but they're gonna be in the middle of it if something happens.
Because they're naming the town of Clinton as additional insured, you mean?
No, just because they know what kind of liability and stuff should
Oh.
reasonably be expected.
You said they were going to be in the middle of it. I was like, I
Well,
don't know that
yeah.
they will be, but
Well, insurance matters, they get in there. It's not our insurance, but still, if it's not properly worded or something like that, it could cause confusion in being resolved. Okay, the last one, on that page 5, F, little f.
Before you go there, Ray.
Okay.
There's just an extra "the" in
yes, you're right.
second line,
Thank you.
E.
Oh, okay. There's another attorney note for that one, a waiver signed by the owner, giving access to the ZA. Questioning the legality or how it works or
Oh,
something.
yeah, well. Yeah, so Shane said he has concerns that this provision constitutes an unreasonable search and seizure in violation of Fourth Amendment. His recommendation is to delete it. Alternatively, we could revise and state as a prerequisite condition to the granting of the special use permit or renewing the special use permit, the zoning administrator must be allowed access to the dwelling or accessory dwelling unit for the purpose of verifying compliance with the provisions of this section. 250-69.1.
How are they different?
Yeah, I don't know how it's different either, but I would change it to his wording if that makes him feel better.
Yeah. The other part of it was, in
But,
addition to his
I mean,
comment.
Access is access, whether they assign something now or assign something later. So
Yeah.
if it's a constitutional issue, that's going to apply either way.
Well, I think what this isn't them, like, his wording is not them signing a waiver of giving up those rights. It's just saying, we're not, unless you allow us to come and inspect, you're not going to get your,
Right. Or if there's
Your
a
permit.
problem. Now, the other part of it, on the top of page 6, where it says, access to the property for the purposes of inspection to verify compliance with provisions of this section, I would add inspection inside dwelling and property. Otherwise, what's he looking for? What's he inspecting?
well, he's inspecting it, that everything's in compliance with this section,
Yeah, I know, but
whether that's something that's inside or outside of that.
I know, I just was trying to be a little definitive, that was all. So there's no question. Bill.
I think we should use his wording anyway.
Yeah,
You know, one of the complaints that people are having is that all these documents are getting way too wordy.
yeah,
So I think it's implied when I say I'm gonna inspect your property, what it entails, ask the building inspector what it
Yeah,
entails.
when it says to verify compliance with the provisions of the section, I think that kind of indicates what they're inspecting.
I agree.
yeah, but see, this is the zoning administrator is doing it. And zoning administrators normally don't do building
Yeah,
inspections.
but we're cutting this sentence anyway and using Shane's
Okay.
wording.
Okay. Now, the other, next one is G, visual depiction. Are we looking for photo, video, or nothing? I don't know, including driveways and parking, or is it just a plot drawing?
Yeah, I don't.
What is it?
Well,
What do you want? I don't know what you want.
we didn't want to force people to have to go out to get, like, a professional drawing of their property. We thought that was too much.
Well, but you could say a sketch on your property or something, plot lines? I mean,
including sketches or
yeah, sketch of your parcel.
sketches and/or photos.
Yeah, whatever. I mean, they do that whenever they come up for planning board or building inspector. I mean,
Yeah.
for buildings, I mean, they're not doing architectural things.
If we're trying to be helpful here,
Sure.
I wouldn't say a sketch, because that means you have to draw it. Why not, I mean, depiction to me is generic, it could be anything.
Yeah.
If you want to say it could be a photograph, or a sketch, or a plan, just to give the person flexibility, enough information for the zoning administrator to act on it and evaluate it.
Right.
Okay.
Okay. Then we're getting into the one we were talking about before, under number 3. Type 2
Oh, yeah.
short-term rental permits are limited to one per owner regardless of the number of properties owned. And page 7 was his comment.
Hi, Jeff.
Hi, sorry. So if we eliminate the word owner, change the word owner to property and eliminate the rest of the sentence, so it simply says, type 2 short-term rental special use permits are limited to one per property.
That may not work right, because, for example, you could have a big house, big colonial farmhouse. You rent out one room in there, but you also have a big garage with a second floor that's used to be a apartment or something, and you rent that out, so that's 2 on one property.
But it's different structure, same property.
Yeah,
Right.
but this
Right.
says per property.
Well, this was to try and prevent someone from buying up multiple properties in town and having multiple short-term rentals throughout the town. So it wouldn't be a corporation coming in and just buying a bunch of properties.
Right. Well, I don't know that you can do that. I understand the intent,
I know. That's what I'm being told, yes.
but I don't think that that's feasible. It would be an expensive but creative workaround from applying for as a conference center, I suppose. And your properties would be very divided. I don't know how likely it is that someone would do that, but I understand the intent. I just don't know that it's doable. Because again, the owner, it refers to the owner of record, so I think it was, as Shane had mentioned, they simply form another LLC, which is a minor amount compared to what you'll make on the revenue.
Yeah, yeah.
Yeah, it's,
I mean, for instance, I know that the Beekman Arms, 20-plus years ago, when they were getting to their room capacity, started buying up properties and having overflows go to those properties because they were farming it out to other Airbnbs in the community. And they said, well, we're losing this money. Let us start grabbing some extra buildings and
Yeah,
stuff
yeah.
like
or
that.
made
so-
the Delamater House.
Yeah, and those cottages all behind it, yeah.
Right.
Yeah, I mean,
How do you stop that?
Hi, Ian Schrank. I mean, I sympathize with not wanting someone, an entity or a person buying up 20 properties and in effect having a hotel,
Yeah.
even though it doesn't sort of look like a hotel. But I also don't know what the source of the lawyer's concern is. You know, if you said you're going to have no more than 2, would that be okay, or no more than 3? Or is it, what is, if I knew his
I think
concern.
his answer is none. You can't limit,
But you know
can't
why?
limit
What
any.
legal principle says you can't do this? Because if we knew the principle, then we could maybe figure out how we can protect the town but comply with the principle and compromise somewhere in the middle. But
yeah, all he says is that it's restrictive and he doesn't think it would withstand a legal challenge. He doesn't say why.
I mean, maybe we could just ask him what the reasoning is, and is there some halfway measure we can do to still have some protection for the town? And it seems very unlikely that someone might have 2 or 3, which to me is no big deal. If someone buys 20 properties, I would say, gee, that doesn't sound right for this town. But it's also very unlikely that that would
Sure.
happen, I think.
Yeah, I mean, it's something that's been happening in cities, but I don't know about it happening here in the town.
Yeah. So you'll check with Shane.
Yeah, yeah.
Move forward. Okay, the next one comes, next thing is Appendix C, Type 2, is not in local law thing that we talked
Yeah, yeah,
about
yeah.
before. Then we get near the bottom of 6. Let me just
Before you
see.
get there, right,
Okay.
the 30 days thing, I guess.
Oh, yeah, the 30 days
We already
again.
talked about 30 days to
Yeah,
to review
I had
it,
marked
rather
here.
than to issue a report, 30 days to review the application.
Oh, to change the wording again?
Yeah,
Yeah.
to match what we came up with before.
Okay.
Okay, then coming down, it says, the zoning administrator's report shall also include violations of the town code at the dwelling or accessory dwelling unit. My comment is, all the violations, the open ones or the closed ones? What ones do you want?
Well, it's not a violation if it's
It's closed,
if
yeah.
it's closed.
Close, it's
Well,
done.
it was a violation. I would put if you want open, put open, include open violations, then it's
Well,
definitive.
violations are open by their very nature. Otherwise, they're not violations.
Yeah, cured violations are no longer violations.
But, whatever.
Yeah, I was
And
just,
if you want to open, I don't think it changes much, but
I just thought,
again, we're adding words.
one word, yeah.
Yeah.
Okay, top of 7. Oh, nobody got up. Okay, the top paragraph, first line. Noise, I want to add smoke and particles in air. Because they could have a big barbecue and really smoke up the countryside.
inviting trouble from Deer Ridge Drive.
Where are you going?
Well,
Where are you going?
it's the way you measure it. No, I don't know what numbers are.
I mean, someone's cooking on their grill and they make smoke. Is that now going to be
Yeah.
terms of one neighbor fighting with the other? I mean, I just think you're being very loose with that term that could be
We
easily
have the same
interpreted
thing with
any way.
noise. We have the same thing with noise.
Well,
We
noise
have the same
usually
thing
has a
with light.
decibel.
Where does it read?
You can make
He wants
particles with a
consideration of
thing. I
noise. He
don't
wants
know
to
the
add
number
smoke.
from the federal level.
Ian Schrank, this just says which may include
Yeah.
these things. So a little grill and you're cooking hamburgers, the
yeah.
zoning administrator should ignore it. But someone who's burning a wood pile every week, that would be a problem. So it says which may include. So it's
Okay.
just discretionary. I think it ought to work.
I just think it opens it up to.
They don't get the
Giuliano
emails we
again.
get.
So, yeah, I mean, this has been obviously a current or fairly current case that with the ZBA that we took on. I think that's going to open up a whole thing if we had the smoke issue on there after, countless hours and going through some other issues that kind of went along with this topic. So I'd really caution putting the word smoke in there. And a lot of the stuff that was determined was through the DEC on there. So I think that's just, and it's subjective. That's the other part.
Particles in air is not subjective. There's a meter. It's parts per billion.
Well, who's going to enforce
Who's
it?
going to do that? Do we have a meter to do that with?
We'll buy a meter. We can buy a meter for
I mean,
that.
we're going to have a whole closet full of meters.
No, we only need light, sound, particles.
Claire?
It's only three.
Yeah, noise I could see. Decibels are easy, all right? But
Well, the next person we're going to have to hire in town is a constable.
someone to be, well,
We have constables.
We don't
have three
have
of them.
that's going out and citing these violations.
That's within their purview.
Well, that's what I'm saying. We're going to have to hire them to do it, not just watch the court.
No, they have been used in the past. We also used them to deliver summons too.
Jeff Newman, correct me about this because I might have it backwards, but we went through this with the events law. It's a sound ordinance, right, not a noise ordinance, and the reason is that sound is subjective, noise is not. Noise is by
Decibels.
person. No, sound is decibels. Noise is not
Okay.
actually measurable.
Okay.
Noise is about discomfort. So I think the key here is having things that are measurable, so it's not subjective, so that somebody couldn't come out and say, "Oh, your barbecue grill is too big," because I don't like it, as opposed to it's emitting X number of particles into the air.
Right.
So the air pollution, I think it does get kind of tricky thing, but I would recommend changing noise to sound, or making some reference to the sound ordinance that currently exists.
I mean, it's like, this is hunting season, and some people might want to go out and have their meat smoked out in their driveway.
Right.
Someone might find it offensive. I don't know.
One might.
Give them a piece of me. Okay.
So invite your neighbors over for dinner, and you don't have a problem.
that's right, absolutely.
And going down just about in the dead center, paragraph number 7, it says if the ownership changes for the units here, the new owner must complete special use application before renting out and pay the fee and all of that. The only thing I was thinking that maybe, and without seeing the form, I don't know, does it need an inspection again?
Well, it's the renewal application, so they can go out and inspect again if they, it's the whole renewal process again.
Yeah, okay.
Shane did have a comment on that as well.
Well, what happens if somebody buys, we had this conversation before, somebody buys a property and then applies for it and is rejected? And said, well, the reason I bought this is because.
I wanted to use it for this.
Because it was getting rental income of.
Exactly, and now you're telling me I can't. I mean, so what?
So you're saying they bought a short-term rental that has already been approved, and then they go
Yes.
to renew,
Yeah.
and it gets denied?
Exactly. I mean, we had this conversation about the
We had
concept
it
of
before.
the special use permits, whether they stay with the property or go with the
Well,
individual.
yeah, that's where
And they
this,
stay with the property.
Yes.
they
So-
do.
So, I mean, how can you differentiate this from somebody who has an accessory dwelling over a garage or any other special use permit?
Well,
Person has to apply before he buys the property. And then if you get turned down, you maybe reconsider your decision.
Or you put
Yeah,
a
I mean,
clause in the
they would end up
contract.
having to renew anyway, at some point, right?
Well, yeah, I mean, there is that.
So, I
yes,
mean, I think if we
but
just
not
ask,
immediate- but not immediately.
instead of completing the special use permit renewal, maybe we just ask, as Shane was suggesting,
What is it?
that they just re-register so we know who the new owners are,
And they get the whatever.
and they
amount of
have
time.
whatever time is left. They get credited
think
for
that's-
what's been,
Yeah,
I think that's more,
yeah.
yeah, I think that's more fair to the
Okay.
new owner, sure.
Yeah.
I don't have that set, I have. the
yeah, he
clean-
wrote,
I
say
have
the
clean
previous
version.
owner paid the fee a month prior to the sale. You do not want to give the new owner credit
Yeah.
for that, question mark? I
Right,
understand
right,
making them
right.
file an application so the town is aware of who the new owners are, but this seems like double dipping.
Okay,
The expense could have
Yeah.
been credited at closing.
so all they have to do is basically register, and they get to continue the.
Yeah, so that we know who the new owners are, but they will have whatever time period. I mean,
Is left on the.
if there's a
applicant.
reason they're gonna get denied no renewal, that's still gonna happen.
Right, exactly,
But
but they,
that's
but they don't have to do it right
We're in
away,
the state of double dipping.
so, okay.
You buy a car, you sell the
I know,
car,
I
you
was
pay
like,
the
double
tax
dipping,
again.
we should want that.
Talk about double dipping.
Among other things. Okay, down in E, general
Everybody's
requirements, number 1, it says, short-term rentals shall only be permitted in
Oh.
no zones.
Oh, yeah, that was an ad by Shane.
No
Uh,
zones. So
yeah.
it's not permitted any place.
Aren't B and Bs permitted everywhere?
I think it should just be everywhere.
I think B and Bs are permitted everywhere, regular B and Bs, if I'm
I
not
think
mistaken.
it should say short-term rental shall be permitted in all zoning
Yeah,
districts.
why would you differentiate?
Sorry, that isn't.
Okay. I just saw it was blank, so.
Yeah, no. You and Shane saw that.
Okay. Now, the next paragraph 2, below that one, it says, the zoning administrator for type 1 short-term rentals and the planning board for type 2 short-term rentals shall determine the maximum number of lodgers allowed in any short-term rental and the maximum number, et cetera, et cetera.
Yeah.
What is a lodger? Is that an adult, a children,
A
and
lodger
babies?
is
Here's the
any
definition.
person or who occupies a dwelling or accessory dwelling unit or any part thereof while it's being utilized as a short-term rental.
Look on the at the beginning.
Yeah, I
So
know,
it's a
I see
person.
that.
It's a person.
No, I know it's a person. I
Well,
know
that's
that,
what I mean.
but
So it
but
doesn't matter if it's a child or an adult, it's a person. The number of people.
So, okay, includes children,
It would be,
adults, and
yeah.
everything else.
Yeah.
But I just wanted to understand that, because I wanted to be sure. So if you brought,
But we did mention, we did indicate adults when it comes to like visitors, like if you have
yes,
friends
no,
in the
I
area that come
understand
to stay.
that, yeah. But, you know, I was just concerned that, you know, say a young couple brought their baby, there's 3
Yeah.
lodgers in one room, and you're only allowing 2 lodgers
And you know that's
in a
going to be
room.
violated a million times and no one's ever
I-
going to be.
Well, we won't even know, we're not a
We
baby
won't even know.
count, unless the diapers are out there.
Exactly.
Yeah, because that appears on the next page, on page 8, where it says, "It shall in no case exceed 2 adults."
Yeah, well,
Adults are over 18, over 21?
no, it's 18. We can't limit it to 21 apparently.
Well, I don't know, I just.
We
asked.
tried.
Yeah,
Legal.
2 adults per bedroom intended for the lodger or 12 lodgers. Let me ask Shane about babies and adults.
and it says 12 lodgers
Yeah,
for the
and then-
entire dwelling unit, whichever is less.
Okay.
So, don't have too many kids.
Tell me about it.
Coming down to that same paragraph, but the second last line, it says dwelling unit use a short-term rental. I think you left the word as out.
Short-term.
And then daytime visitors are permitted between the hours of 7 a.m. and 11 p.m. And then there's again a Shane comment on that
Yeah,
one.
he said, I mean, and we know that. It
What is-
says very broad and difficult to enforce, and I agree, but I think giving people some parameters of how to
Yeah.
stay in compliance is better than giving them none.
Yeah, all right.
So in that last sentence, can I host a wedding?
Where, what, last sentence?
Yeah, it says daytime visitors are permitted between the hours of 7 a.m. and 11 p.m., but it doesn't give me a limit to the number of daytime visitors I can
Well,
have.
no, there is a limit. The maximum number of adult daytime visitors shall not exceed the maximum number of permitted lodgers in the day, so there is a limit on it.
So no more than 12 lodgers for entire dwelling or accessory unit, which.
So if you
whichever is
had
less.
a
So
property that allowed 12 lodgers, you could
Right.
also have 12 visitors during the day.
So I could have a total of 24 people.
Yeah, there would be 24 people total.
Okay.
So you can't bring a busload from New Jersey
But if
up.
it was
Right,
a
yeah.
house that had 12 lodgers, I imagine that it has at least 6 bedrooms, and it's probably a large property as well,
Right.
With a big
Right.
septic tank.
with a big
Yeah,
septic
hopefully.
tank.
Hopefully. Yeah, I would recommend making that a little more clear, again, as people are looking at, should I buy this property or this property? And I can get around this law by buying this property and having, as many people as I want, and then come to find after they bought the property, they'll know, oh, I can only have 24. It just doesn't seem as clear as maybe it could be. That there's a maximum number of daytime people on the property at one time.
Well, is the purpose of this to discourage large gatherings, presumably?
Yeah.
Yeah.
Getting 50 or 60 people
So
in
we
there.
don't have neighbors having giant parties next to
Yeah.
people's houses.
No big beer parties, like they did in the past.
So, I'm just trying to read it quickly. See, does it state in here, this all describes how the maximum number will be determined, but it doesn't say that it will be determined and posted. And maybe that's the answer, is
And
if the planning
posted?
board is reviewing this and making that determination based on septic, proximity of adjoining residents, potential for noise,
That's what the certificate says.
yeah,
Max.
right, and that, I mean, if they were a temporary residence, by the health department's rule, they would have to have a posting of what their capacity is, for example.
Are these rules going to be posted at all of the sites or not?
They got to.
Yeah.
They should be.
There was a spot in there
Like
where it
max,
said it.
okay, maximum occupancy or number of guests or
Should
whatever.
be.
Yeah,
Yeah, the emergency phone numbers.
yeah,
Yeah.
yeah, yeah.
All that.
It's just like the maximum number of people in a room
Right.
like this.
Yeah.
It's posted and figured out. Okay. Then
So
we
what are we
come,
going to do with that? Leave it?
I'm just gonna make sure that it is posted.
Okay, all right,
I'll make sure it's in that other section where.
okay.
okay, then coming down in number 4, same page, in the middle there, it says, to ensure the lodgers do not create noises, we should put that sounds,
Create
consistent.
sound or disturbances.
just to be consistent.
Yeah.
We did it before.
I'll also, when I'm doing it, just search for the word noise in my document and change it to sound every time.
Well, when it,
Yeah.
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 So, well, you just, when you do it, you just accept the change rather than just routinely change them all. Okay, the end of that paragraph, the last sentence, let me just see where we are here. Trying to figure, oh, there it starts. The owner of the dwelling accessory unit shall, upon notifications from the ZA or building inspector that lodgers have created
Sound,
noises, no, that's
sounds or
noises.
disturbances.
That's
Noises?
noises, yeah,
Right.
yeah. Yeah.
Okay.
Noise
Or-
is- Noise is qualitative,
yeah,
sound is measurable.
yeah,
the
or
Yeah.
disturbances engaged in disorderly conduct or otherwise violated provisions of the town code or any county, etc. Properly use best efforts to prevent a reoccurrence of such conduct. I wanted to add best efforts to cease existing and/or prevent a reoccurrence. In other words, you want to be able to stop it now. You don't want to say, okay, keep on going, having a big party, enjoy yourself. The next time around, we'll say you can't do it. You see what I'm saying?
Yes. I do see what you're saying completely. The way it's worded is
its own.
Upon notification from the zoning administrator or building inspector that lodgers have created, it's sort of as if this has been a complaint, they've come, it's already over with,
Well,
and it
I
has
don't-
ceased, but
well,
yeah.
But, you know, by putting a cease existing.
Cease and or prevent a recurrence.
Yeah,
No, and,
Cease and prevent?
Yeah,
Yeah,
sure.
cease, yeah.
for sure. Yeah, it should be both.
okay, now on page 6, in page 9, number 6 at the very top, it says a short-term rental shall not have any signs indicating it's a short-term rental and other appearance indicating such use. I think that should be combined with the previous one where it says no advertising regarding the use and all. Should all be in one paragraph. I'm not questioning it, I'm just saying, I think you may have to reword it a little bit, but
Sure,
it's,
that's easy.
it's maybe even redundant. I'll leave it up, do. Okay, coming down on that page to the little b, under 7, the little b, the 911 address for short-term rental. This is supposed to be on a form available to the people. I was going to say we should add fire and/or medical emergencies after it, because you can have people from foreign countries come, or Canada or whatever, and they don't know what 911 means. So I'm just saying fire and/or medical emergencies.
Okay.
Excuse me.
And then the maximum number, then the next one, little c's, maximum number of lodgers permitted to stay in short-term rentals and maximums. That's sort
These are
of,
the things that need to get posted, by the way.
yeah, so that covers what we
What
were
we were
talking
talking about.
earlier. And then, okay, and that little e, this is an interesting one, because we've had complaints over the years, and it goes in and out of vogue, on trash cans. It says pickup day and notification trash, et cetera, et cetera. We should state how many days early out and how many days late to remove the can. Because people, for example, this is a weekender situation, but I'm using it as an example. Say they're only here Friday, Saturday, and Sunday. Monday, as they're walking out, going to New York City, they leave their trash can out there, and they come back the following Sunday. It's out there for a whole week. We've had complaints of people having them out, or whatever, yeah. So this would give the zoning or the authority ability to say, hey, you're in violation, you just left the cans out too long, you gotta better
So what do we
handle it.
wanna,
Well,
This is an issue more than just even here.
I know,
It's an
I
issue
know.
with anybody who's basically using their house for, let's say, a weekend house, and
That's right.
yeah,
You know,
part of my, so the conversation we had with this already is, if we're gonna put that requirement in this, then we are creating basically a regulation
Bias.
in the short-term rental where we're biased against short-term people, owners of short-term rentals, and we're not requiring that of somebody
Well,
who
we
just
gotta
lives
do-
here
we
or is a
gotta do-
weekender.
yeah.
This has been from my point of view, I have an unbelievable amount of complaints about the
yeah.
garbage cans. Even on my road,
Yeah.
I get upset
yeah,
driving
well, the
by
wind
the
blows
can.
them down,
But-
the animals knock them
but the-
over, or whatever.
but the
It should
point
be
is-
done in the entire community.
Yeah, and that's what
Okay.
I would like to say. I just don't think we should include it in this and just single out Airbnbs. It should be something, if we want to do that, then it's something that we put in the town code and,
But
make it
as
apply
you
to the
said,
town.
this is what's written and left there for the lodgers to see.
For the lodgers to see. But this, but that's what I'm saying. We're asking the lodgers to
Do the best they can.
comply with
But it's
a
typically.
regulation that doesn't exist for the rest of the
The
town.
problem
I
with this
know.
is that it puts the onus on the lodger.
Exactly.
That
Yeah.
should be on the property
It should
owner.
be on the
the-
property.
So
exactly.
rather than creating a situation where the
Exactly.
lodger says, oh, I have to take the trash out,
Exactly.
No,
have a description
Right.
of what the
Right.
lodger should
Right.
do with the trash,
Yeah.
which is probably leave it in the house.
I
Or
think,
even put it in whatever sealed trash
exactly,
receptacle or
but
whatever.
not have to take it out to the curb
Yeah,
and bring it
right.
back in. I mean, that's something that the property owner or the
Or
property
the caretaker, or
manager should
whomever,
be doing.
exactly, right, right.
Right?
And not put the onus on the guest.
I'm the lodger, I'm not gonna be taking out the trash.
Exactly,
Right.
right.
Yeah, and I've rented Airbnbs. They generally do
That's what
have
they do,
that, like,
yeah.
you know, please leave the trash wherever, you know,
Exactly.
yeah.
Right, so a description of how to handle the
Okay.
trash, not when to
I've
take
never
it out.
stayed, so I don't know
Yeah,
that.
yeah, they don't, the lodgers don't do that. The owners do that, or the
Right.
managers do
So
that.
I'll
Right.
change the wording around a little bit.
And then I was wondering if you left F blank because that was where you put the
F
map.
got deleted, yeah.
Oh, I thought that
but-
was going to be the map of the house. Well, I mean,
emergency
seriously,
exit type
emergency
map.
exits, right? So the health department, for example, in temporary residences requires that at the back of the door to the room, you have a very simple layout of the building with the emergency
With
exits.
red arrows
I would
showing how you
recommend
get out.
putting that posted in a common area.
Okay.
Yeah, that's
Okay.
actually not a bad idea.
Yeah. Yeah, now we can add something to F. Because I was violating the Fourth Amendment with the previous F. What was that?
We checking the end of the book first?
People are here for other things.
Okay, number 10, on the top of the page, little b, it says smoke detectors in appropriate locations as required. I was just saying smoke and CO detectors in appropriate locations as required.
Yeah.
And that then takes the E and gets rid of it. You don't need E then, because that just talks about carbon monoxide.
Right.
Inappropriate location as required, yeah, okay.
So
Yeah, yeah.
So then E can be removed. In F, fire extinguishers, I think you gotta specify size, which is normally pounds, and type, whether it's powder, CO2, whatever.
Yeah, this is
General-
wording that I got from Lewis.
Yeah,
But
but, you know, if you give it to the guy and the guy says, well, he went and he got a little one like this, you know.
yeah, no, 10-pound
might as well
ABC
not-
would cover everything, but,
Yeah. So, you know,
okay.
it's just picking some numbers. Now, the other one is G. And this is, I think we're getting in the wrong name here. It says, all stairs, porches, and decks, both indoor and outdoor, shall be properly illuminated and safe as determined by the zoning administrator. The building
That's the
inspector,
building
Oh, yeah,
inspector.
building.
the guy that
yeah.
normally
Yeah,
does
sorry
that.
about that.
Okay, and H. This is where they're putting the address signs, the house address signs. The only thing I made a comment here is on both sides, because most
Yeah, yeah.
address signs are only on the way the post office goes. The fire trucks come on both sides, depending on where they're coming from. And
I live on a dead end.
Oh.
I don't have that problem.
only if they remember that it's the old name.
For you, then it has to be put on the right side.
Yeah,
Okay, so that one's simple. Then going down to B, little b at the very bottom of 10. On the basis of 2 persons per sleeping room. What's the age of persons now?
2 lodgers.
Well, that includes babies then, so you can't have babies in there. So you gotta leave the baby out in the hall and the adults, the parents sleep in the house.
That's right.
Yeah, this was changes. I don't know. So you're just asking if babies are included?
Well, yeah, or, you know, 5-year-old kid or whatever, I don't know.
Yeah. It's the thing, they're gonna lie about that every time. Whoever's renting it's gonna lie.
Well, yeah, you've experienced that, right? You know how to do
I've
it.
never lied.
Yeah, I just
Well, if
Let's
the
be
septic
realistic.
system is designed
Yeah,
with anticipation of 2 persons per room,
yeah.
I mean, unless it's an infant, I mean, they're all using
Normally come with
the...
diapers.
Oh, I
And in
agree. I'm
fact, if
just
they're
saying
younger,
that-
they're probably taking baths, which means more water
Yeah,
use
yeah.
than a shower.
I agree. I'm just saying that people aren't, like, the people that are renting it are just gonna say, oh, well, then it's 2 adults, and they'll bring their 2-year-old with them anyway.
Right.
I know that.
The health department looks at septic design based on room, not number of people. So each room in a temporary residence is rated 110 gallons per day. In a residence, I don't know what the number is offhand, but it's still a number of bedrooms.
Yeah.
That
Yes,
would,
it's
that
all
would
in
do that. So that's what,
But I'm sure they're using rooms or bedrooms with an assumption that only 2 people are living in there on a full-time
Probably.
basis.
Right, yeah, yeah. And that, so at the end of this, where it says, where it defines sleeping room, I think in sort of the same vein is rely on definitions that already exist. So, for example, if you, for that sentence, a sleeping room is defined as a fully enclosed habitable space of at least 70 square feet for one person and emergency escape. Dwelling is defined elsewhere in the town code.
Well, so this was all added by the town attorney, and his comment there was, I know the county has approved this language.
Okay,
So, like all of, yeah, the whole last page and a half is
Yeah.
all things added by Shane.
okay. So then my last question about B then is, what happens if the room is below 100 square feet? It just says unless it's below 100 square
Purpose
feet.
of sleeping room is.
Does that mean I can have 6 people if it's below 100 square feet?
No, habitable space of at least 70 square feet for 1 person
100 square.
and 100 square feet for 2 persons. What happens if it's between 70 and 100? I have no idea.
So this says,
Oh, it's
but
one
it says the
person.
number of people calculated on the basis of 2 persons per sleeping room,
And
unless the room size is below 100 square feet.
But then, because
Then
it's
it would
only
be
one
one.
person,
Then it would be
It'd be
1.
one,
it'd be one person. Because you need 100 square feet for 2 people,
yeah.
and a minimum of 70 square feet.
70 square feet is essentially a
Is
jail,
Is an
jail
absolute
Yeah.
minimum. So up to 100 square feet
My first apartment.
would be between 70
Yeah, I
and
think there's a
100.
disconnect between these
would
two
be one
sentences.
person.
I think that having the latter sentence clarify the previous sentence creates a discrepancy, where one could argue that it doesn't satisfy what the unless is.
I think he even knew that, and that's why Shane wrote, the county has
It's sort of
approved
those
this
one of those
language.
person knowledge things is, yeah, when you know it, you forget to sometimes how to clarify it.
Yeah. But I think he knew that it was confusing, and that's why he indicated in here, in his comment, that the county approved this language.
Okay.
So the implication is that we should just use it the way it is.
Let the ZA figure out what's happening.
Yeah, I might just swap the 2 sentences, that's all. Start with, for this purpose, and end with the other sentence. Then at least the definition is first.
And the very last line of that same paragraph, with an emergency escape or rescue opening, I was going to add the words proper legal escape. Because people can say that you can go out this window, but the window's got to be a certain size, or you can't call it an escape place, or
Yeah, but the building inspector's gonna
Wouldn't
look at
that
all
be
this
part of the
anyway, so
inspection
it would be part
process
of
to
it,
begin
so
with?
should be, yeah.
That's why we have a building inspector.
Yeah. Yeah, that's better. Okay, I'll go with that. And surprise, surprise, I have no more.
Oh, thank you.
Do you have any more?
No. I sent you what I had.
The answer is no.
Well, you know, I don't want to let you off here. Get you some other words here, so.
So we'll pick this up at the next board meeting?
Yeah, I'll try and make these update ones, and yeah, I'll try and do this over the next few days. I got a lot this weekend, but
And there's no update on the events thing. You want to do anything on the events, or just leave it the way it is right now?
Still at
So-
the
so-
lawyers?
Yeah, so
Okay, no, I just,
A revised plan from the attorney and county planning. Nothing more to talk about it, but, county planning's idea was to separate the conference center and
right.
just create this new section for events, or agritourism, or whatever they want to call it, but they wanted to separate it. So where we left off last time, we kind of talked about it, but we didn't do anything, was 250-64.
That's what I'm just trying to find where that is.
That was a long time ago.
C, right?
Hmm?
C, I have down revised.
We talked about it, but we didn't do anything.
Right.
So we started talking about it, but it was late.
64, okay.
Russ Tompkins, Shellsville. Had to get up, my legs were getting stiff. Yeah, I had down here, we're gonna do it, and I remember bringing up C to you last time,
Right.
where I said, it's ridiculous, completely screened from roads and neighboring property. I said you'd have to build a 10-foot wall around your trailer. But looking at it today again, any such recreational or commercial vehicle or bus that is parked or stored only in the side of rear yard of dwelling unit, and if stored, shall be completely screened. Now, what's the difference between parking and storing? I circled the or. I'm considering all my stuff parked, so it's not stored, so I don't think this applies to me. I mean, there's not a definition, I don't think, of parked and stored. And there's two different options here.
Again, as a committee, we didn't even touch this, so who made it, why they made it, and why nobody's enforcing it, I have no
Yeah,
idea.
well, I mean, I know you didn't touch on this, but now's the time to correct
Sure.
things that I think need to be addressed. And I
Sure.
think that, as I said, if you drive around town, an awful lot of people have camping trailers, and it's in their side yard, it's in their backyard, it's not serving any detrimental effect upon anybody, and to say you gotta completely screen it from roads and neighboring properties is just,
The problem is beauty's in the eye of the beholder, and so you may park your cars this way, and someone likes to park their cars this way, and someone who parks their cars this way doesn't like the fact that you park it that way, and they complain. So where does make one right and one wrong? I mean, I think when we have registered vehicles versus non-registered vehicles, that's always been an easy way to kind of filter out, a junkyard versus, someone who's just got a vehicle that's off-season, that's parked, stored, whatever. I mean, I also don't like the word stored, but, that's,
well, these recreational vehicles are obviously registered.
yeah.
I have to have a plate on that trailer, and it's in his side yard, and it's not, I just think that this is, like I say, completely excessive and should be removed, and completely screened from roads and neighboring properties.
Well, what you can do is go to one of these army places that sell stuff, buy camo, there's netting, and you throw it over the vehicle. You've hidden.
Well, I mean, I can buy a recreational vehicle cover for several $100s
No,
and
but
put
I meant-
over it, and I mean, it's,
No, I meant it's camouflaged. It's not the typical covering.
yeah, well, I can go out there with a spray can and paint it green and tan and brown, and it'll be camouflaged.
All right, so let's be more serious. How do we
So,
want to
I just think that's
address this?
ridiculous thing to be in there.
My problem with, all the laws are that there's really, the law is really kind of a one-size-fits-all, and, certainly if, unfortunately you, Rush, you're very close to the road, no matter which side of your property, because it's all along road frontage, versus someone who may
And a hill and behind
be
them.
1,000 feet off the road, and they could have 20 campers, and you never know.
Yeah, a lot of school bus drivers store their buses at home because that's where they start to drive from.
Well, I wouldn't call it stored, I'd be
Like
called
parked.
parked.
Okay,
but,
well, it doesn't matter. It's
I know.
both here.
I know.
As he said, it's both.
There's some people that buy school buses and store them.
Yeah, well, that's different, but I'm just saying that they get plates on it and everything else. Yeah, it is a challenge.
So, I mean, this whole section's about outdoor storage and parking of recreational vehicles, so,
Or commercial
Or
vehicles.
commercial.
or commercial
Yeah,
vehicles.
not just recreation.
Just to make your life more complicated, Ian Schrank.
Thank you.
I had two comments, and I'll add a third based on what you're just talking about now. First comment was, I was hoping this could also apply to containers. They're not vehicles. I realize that, the box that goes in the back of a truck. People sometimes store, have those things sitting on their property. They're just as ugly as everything else. They really don't belong there.
You mean a shipping container?
Sorry?
Shipping
The shipping
container?
Yeah, shipping container, yeah.
Yeah. They normally request and get a building permit to locate them, and they gotta comply with setbacks and stuff like that.
Why would they need a building permit? They're not permanent.
That's what we've been doing, getting building
Talking
permits.
about,
Just to store a
you're talking
shipping.
about storage units, like when people are having work done on their house and they rent one of these
No,
things.
no,
No, well, not
Like
something
a
that's.
tractor trailer.
It's the back part, not
Yeah.
with the wheels.
Right,
Or it may have wheels, but
Yeah.
it's the back part of the tractor trailer
Yeah.
that people sometimes use for storage or
They
they.
ship stuff from Europe to us on container ships. Those kind of
I mean, something
things.
that's temporary because you're building a house, I
different.
wouldn't object to that, but it's the storage part that I think should be regulated, just like for the same reasons the other stuff's regulated. To me, it's no different, really. That's comment one.
I
would
mean,
hope-
people, and, obviously it's not for permanent use, but people will rent
Yeah,
to
Pod.
move those pods.
Right.
And not a problem
Well, that's
with, if
different.
it's temporary, you're moving, and that's fine, we all do stuff like that, but people often just keep them there, or they dump them there, just because they had them once, they have nowhere else to put them.
They can't sell them.
And I think that it should be regulated in the same way. To me, I don't see any difference between a commercial vehicle and a shipping container. And I think there is a difference between parking and storage. I'm much more sympathetic to someone who has a recreational vehicle that they're using regularly. They park it in their driveway like anything else, but if it's going to be stored there and not used for 4 months, then to me, that's different.
It sits there all winter because you can't go out on the roads with them.
Well, I understand. So to me, that's the difference between the two. And my last comment is in B. At the end, it says C 250-23. Well, as I read 23, there is no such provision about a minimum yards to a lot. There's minimum yards to the street, but not to other lots. So there's something missing somewhere.
Oh,
It says shall not be within the minimum
yards
yards
are
of a
meant
lot.
their back, front, and sides.
If
They're
you read
called
23, it only
yards.
deals with the front yard and the distance
Oh,
to the
okay.
road. It doesn't deal with side or back.
Okay.
So some things needs to be filled in there.
So 250-23 is measurement and use of yards.
Yep.
That's a front yard setback.
There is nothing about back or side.
Those are generally on the different zoning areas. Hamlets, 3A, R, 5A, R5, they all have those numbers on that chart.
I didn't check all the zoning rules. It may be the problem is it should reference not just 23, but other sections also.
Well, 25 is rear.
Okay, all right, so maybe that's the problem. You just need to reference multiple sections there. I didn't know where to look for that.
Yeah,
And we can go into the 250 attachment too, with the, if we just set it as the minimum yard setbacks, you know, putting it as far as where it says, let's see, I'm sorry, I lost here. What's in my other book? Bear with me 1 second. Because I think the thing that's confusing here is it's saying, not to be within the minimum yards, I think the minimum yard setback of a residential district, and the section 250-23, I think Ian is right, because it says front yard setbacks on that page, but I would reference it to the attachment as of the current zoning law of 250 attachment 2, because then it gives all the setbacks
right,
on that in our current.
for each zoning district.
Yeah, for each zoning district, that's what I would kind of bring it back into. And currently, like I said, that's attachment 2. If that changes in the final layout, it might be a little different.
So, let's take one of these at a time. So in B, do we want to add in 250-23, 25, and attachment 2 for setbacks?
Yeah.
Yes.
Do we need to even say 23 and 25, or do we just, attachment 2 just has all the setbacks?
Yeah, all
But
the
this
setbacks are-
describes what a setback is
Okay.
in the 22 or 23.
Not a hill I need to do, so.
Yeah.
Yeah.
And then in C, how do we want to deal with this?
Hang on just a second.
How do you define parked versus storage? I mean, to me, if it's a recreational vehicle that you're gonna use periodically versus a trailer, tractor trailer that you're putting there and it's not moved, et cetera, I just kind of feel like, and certainly in the case of Russ, I mean, he uses that. He uses those campers and trailers.
So why don't we put a time limit on it in the sense of saying that if it exceeds 30, 60, 90 days, whatever that number is, then they have to comply to the storage in the rear or side.
To me, storage is, I would define it more to be a permanent, you got it there,
There is
It's there
actually a definition
forever.
of storage,
you know,
but it has no time limit. Storage in our definition say the keeping of goods, vehicles, wares, or supplies for any length of time. Storage includes parking. This
Is that a circular thing?
This definition, however, shall not be construed as including the activities of a junkyard or landfill, as defined herein. That
Not
didn't
do we
clarify anything,
Do
I
we
know.
have parking?
But that's-
And there is no definition of parking.
But that's why I'm saying, if the, you know, what is the intent here? What is it that we're trying to accomplish? You know, it's basically the unsightly,
junkyards.
long-term
Yeah.
parking of these large obstructions.
Right.
And so, you know, if someone's moving and they get one of these storage containers or whatever, and they may take 30 days to pack up the storage unit before they move, that should be acceptable. But someone has 3 boats and 4 campers that are all unregistered, and they're just sitting around because the one broke, so I bought a new one. And then it becomes a junkyard, in my terms. But you know, that's more of what we're trying to get around. So, I mean, I would think that if something's registered and
Seasonal kind of
it's
thing.
seasonal is one thing. If it's something that's not registered and it's just being permanently long-term parked, that's another thing.
So is this also going to deal with construction equipment that we've been having the conversation on as well? Well, it's not registered, and if it sits there for a long time, that's what I'm saying, it would fall under that.
We have a
Right, exactly.
contractors thing.
Well, contractors' yards are already regulated somewhere else.
No, but I'm just saying, that's generally where that, if
Yeah,
it's a
I'm just saying,
contractor.
If somebody's doing work and they're using the equipment on an ongoing basis, then it's not parked. I mean,
Yeah,
it's not stored. I mean,
Yeah.
it's,
And then, I don't know if this, it would include snowmobiles
Sure.
and ATVs
Mhm.
and trailers that associated with them, and they're scattered all over the place.
Yeah.
Now,
It's difficult to try and legislate common sense.
Ray,
That's
Ray,
what
I
we're
had the
that's
same
what we're
question.
coming up against.
Run through my head right when you said that is it apply to snowmobiles and ATVs and this and that, and given the intent of the law, I can understand why it maybe it should, but to that regard, it does say that one is allowed.
Yeah.
So if somebody had a boat and that boat was on a trailer, they'd already be out of compliance with this.
And registered.
Right, but they're not allowed to have a trailer and a boat. You couldn't have a boat and an ATV and a snowmobile. So where's the line? Like, there are people who own those things and keep them well and keep them
Right.
properly in their yard.
or some
So
people
it's-
take their camper and they trailer their boat to
Right,
go
exactly.
to the lake.
Right, right. So it you know, there's, it's more murky than it appears on the surface, I'm afraid.
yeah, it's not trivial. Now, the other thing that happened in the late 80s, a family complained about somebody having a tractor and trailer truck there, and then his wife also drove tractor and trailer, and coincidentally, they'd be there maybe 2 days every 2 months or something, you know, because they're cross-country and all. So the problem came up as a violation using this thing and all, so the guy says, okay, he built a barn to house 2 tractor and trailers. The complainer really complained now because he didn't like this unsightly barn that was there in perpetuity. And I was trying to convince the complainer, they're only going to do it for another year or 2, and then it's done and gone. He said, no, it's got to be cleaned up. So now the building is there and will be there for a century. And the owner, the complainer, went bankrupt and sold the house and foreclosed and all that sort of stuff. So, but I'm just telling you what happens when you force certain issues to occur.
You also read G, that's got a 30-day, you're talking about camp trailer,
Occupied.
Occupied.
yeah.
I'm more concerned about B, 72 hours.
Yeah, I've been going back and forth between those things. And this section actually comes up for us as a property. We often will have people request, we know what our overnight capacity is on our property, and we'll have potential clients that say, well, what if we rent a bunch of Airstream trailers and put them on the property? And I'm like, no. And I cite this section for why it is that we're not allowed to do that. And so I've been kind of going through it a lot, but I think in terms of B with the 72 hours, it's permitted only up to 72 hours. It doesn't have to be owned by the property owner. So you've got your grandparents visiting as they're traveling around the country and they park their motorhome in your driveway up to 72 hours. That's allowed within the law. You cross the 72 hours and then it's not allowed anymore. That's how I interpret that. Where in G, then, no property shall be placed on an occupied camping trailer or motorhome for more than 30 days in a calendar year. I don't remember what section it is, but I think there is a section of the code that applies to building. And if you own a lot and you are building a house on that lot, you are allowed a
Security
trailer for
reasons.
up to 30 days. Is that right? To live there while you build the house?
Yeah, I think so.
Yeah. I forget what section that is, but I would imagine that's why this is here, is that it coincides with that. But I think, again, back to the whole ATV snowmobile thing, this has potential to be larger than what it is here. It's also an alternative way for people to do Airbnb, right? So you get into that. But at the same time, you want people who have vehicles and use them to be able to store them on the property and use them. I don't know the answer. I'm just opening another door to loopholes that I've seen this try to get used for.
In G, where we talk about 30 days in a calendar year, I wanted to add except in emergencies, because there could be a flood or something like that and the house becomes moldy or something, and you can't live in it, or something of that nature, or there's a fire or the wires are down or whatever, and you at least have maybe a generator in your motor home that can give you electricity and heat and cooking and all that kind of good stuff.
You know, you're right with using the example, but I think sometimes we take this too far. Somebody's house burns down and they have a trailer camper in the back and they live in it. There isn't a person in this community who's going to tell them that they can't stay there for a period of time. No?
I guess you have some Bickersons which will complain about it, and you look at the law and they'll take you to court over
I
the
think
law.
it's excessive.
Well, I'm just saying, that's what happens.
I mean,
I hate to single you out, but I've known you for 36 years. Have you ever been cited for the trailers in your property? For having them not screened or not stored
No.
properly?
right?
I understand. Yeah.
He can't move his garage to hide them.
Russ Tompkins, no response, no. I did have somebody come one time, there was a letter sent to the town while I was judge, and it was signed by a person who expressed herself as observer of facts, and it was sent to the zoning enforcement officer, and Bob Fennell come and saw me, and it was about, I think, unregistered vehicles, and at the time, I had 5 deeds for pieces of property. I owned the Triangle, which is 1 deed. I owned the Shullsville Garage, 1 deed. The house, another deed. The woods was another deed. And because there was 2 on 1 piece of property, it was, then the woman denied ever writing it, but I said, okay, would you like me to park one out in a Triangle? I said, that'll be on a separate piece of property. I said, but I'm doing it in a common sense approach that is the least obtrusive to people. So if you really want me to do something, then I said, I'll put it out there in the middle of the Triangle and leave it out there. I said, but I don't think you'd want it out there. And it kind of went away. But the same thing with the trailer. It's, nobody's come after me, but I think by having this here, you never know who's going to be in a position of authority at the time.
And it doesn't have to be a
when they get
neighbor
a
either.
hair crossways,
Yeah.
they have the power to come after you because of it's there.
So, since you brought it up, how would you change it?
I would remove completely screened from roads and neighboring property. I just think it's ridiculous. I mean, if you got it in the side yard, you don't have it in the front yard, I don't think you should need to have it. I think that completely screened should be removed. And as Nancy was talking about before, you have a camping trailer. In this area, campgrounds close usually the end of September, and they open up maybe Memorial Day. So you have that period in there where you're not going to have any place to go to camp. Now, I realize the new motor homes have systems where they actually, the water is all protected from freezing and you use them year round. My devices that I get have always been secondhand at the best price I could get it for. And it doesn't have this elaborate system where I can use it year round. So I have to go and put the antifreeze in it, the biodegradable red antifreeze, and it's parked from the end of September or maybe the end of October through May. So it's going to be parked for that period of time, but I don't know if you, I like the fact that I can see if you have, like you say, you buy the back end of a tractor trailer and put it in your yard, maybe that's a little more unpleasant to look at. But I think there's just so many people that have camping trailers that I think this is excessive to come out with something like this.
And it also applies to snowmobiles or whatever.
Well, you know, you guys have mentioned that. I don't see anything like that in here for snowmobiles.
It says recreational vehicles.
But what's the definition of recreational vehicle?
Boats, snowmobiles.
I didn't think it included snowmobiles.
I don't know where that would be.
More than one, first,
Well, we've defined vehicles as things that are registered, right? So I don't think a
It's
snowmobile.
registered, I think.
It says recreational vehicle.
See camping
vehicle.
Yeah.
So if you go to camping vehicle, it sure doesn't have anything to do with snowmobiles.
okay.
I used to have them too, but they say they're like boats. You have 2 good days with a boat, the day you buy it and the day you sell it. And I felt that way when I got rid of the snowmobiles. Because you can't ride them anywhere anymore. People are, you know, where I'm trying to find camping vehicle. I'm sure it doesn't
Doesn't
mention
say it.
snowmobile.
So I put down, find a definition for recreational vehicle.
I think in a general sense, when these were written, whenever this was written,
Yeah, there probably wasn't many.
it was a little more of a common sense approach and not having to
Right.
define everything.
Right.
Litigation didn't exist too much. Yeah, because the other thing is, if you read most of that sentence, it says, the following shall be permitted only as an accessory use to an occupied principal dwelling unit. Boat over 15 feet, boat trailer, cargo trailer, camping vehicle, any of which shall be owned for personal use by the resident on the premises. But it says one of each. So you can have a boat with a trailer, but you can't have a trailer for something else. And then under 15 feet shall be permitted as an accessory without quantity limitations. So
Stack them up.
Well, I do have 2 boats under 15 feet, but I'm okay, I guess. I don't know what you count canoes. You know, I assume they're a boat too, but, you know.
look under definitions.
But for some reason, I can't find even camping vehicle in here today.
It's under,
Vehicle camping, maybe?
no, it's under camping trailer or
Yeah.
camping vehicle.
It's there.
Well, I got convenience, communication,
Look at camping trailer.
clear cut, camping trailer or camping vehicle, yeah. I don't think you have snowmobiles covered in any
No.
section
No.
here.
I think so.
And they are becoming a thing of the past because of regulations where you can ride them. I mean, if you go upstate, you can ride them on the roads up there. You get insurance on them, you register the vehicle, you can actually ride them on many roads. You go up around Old Forge and stuff, it's big time up there.
Yep.
But
That's tourism.
in Dutchess County, all of us used to have snowmobiles. I don't know if anybody's got one around here now. So that's not a thing to worry about, but I just think that this section completely screened is excessive in light of the number of people that use campers now.
Yeah.
One suggestion to that end, I keep thinking about, again, about our property, where our front yard is 34 acres and is completely screened. So when I first read it, I thought, well, we wouldn't be able to store something on our front yard. but we could because it's screened. So if the language were changed to read, any such recreational, commercial vehicle or bus shall be parked or stored only in the side or rear yard of a dwelling unit, or shall be completely screened from roads and neighboring properties. So the issue is who sees it from the road, right? So if the case is you could store it in the side yard or the backyard, you don't have to have it screened. It's in your backyard. I think most people would consider our backyards as private space. If you want to put it in your front yard, you want to park in your driveway, then the expectation would be that it would be screened.
Yeah.
By changing it from
Well, except
and
it's not
stored
allowed
to
in the
or.
front yard according to this. So that's not.
No, but I say, but you would change the to or, so it's, or rear yard of a dwelling unit, or shall be completely screened from roads and neighboring properties. So it could only be in the front if it was completely screened. Otherwise, it's screened by your house in your backyard.
Yeah, the only problem on corner lots,
Yeah, and just
Where's the
you
front?
get two
Just
fronts.
because it's on the side or the rear doesn't mean it's screened.
No.
Right, and that's what I was saying in response to Russ's concern, is to,
configuration of the
yeah,
lot.
is to eliminate, he wants to eliminate the screening issue, right? So what I'm saying is if you put it in the backyard or the side yard, and by changing that word to or,
That still doesn't mean it's screened. That's
that,
what-
that would be the point, is that it does not have to be screened anymore. That's
But
what
why?
Russ is asking for.
But if you want it screened, you want it screened.
No, he's saying if it's complying with the rear or side yard, then it wouldn't need to be screened. But if you wanted to be anywhere else, like the
No,
front
I
yard,
understand that.
then it would have to be screened.
But what I'm saying is, if you want the vehicle to be screened, then it doesn't matter whether it's side, rear, or front, you
Yeah.
want it to be screened.
If you want it to be screened, that's
Right, which is how this is currently written, but there's a suggestion to be made, is that this is not, this is not doable, right? This one says that no matter where you put it, it has to be
Right.
completely screened,
Right.
right?
Right.
And so the suggestion being made is to change this so that it's not, that it does not always have to be completely screened regardless.
Well,
That
except
a
there
house
is
could be
this, there
considered
is a
screening.
situation that Ray pointed out with corner lots.
Mhm.
Yeah, but we've talked about that in the past as to on corner lots, which side is the
Front.
front, and it's, I guess, where the
front
house
door.
is, the front
Front
door of the
door.
house.
Right, no, I understand that. No, my point is that if it's a corner lot, then, and even if you have a vehicle of some sort and put it in the backyard, it may be screened from,
One side.
but not from the other, exactly, because it's a corner lot, so you see it from two different places.
Right, yeah, the question is a requirement, does the requirement to be screened remain? That's the question.
Yeah, I guess
And
that's
if
what
the-
we're asking, is do
If
we really
that
want
requirement
everything
goes
to be screened?
away,
Well,
right, or if that requirement is modified, then yes, you could park it on what would be the side lot of a corner lot, because your door faces this street, and it would meet this code, and it would be seen by the road. Yes,
yeah, the side is going to be seen either way.
right. And if the law were changed to that, then that would be okay, that would be allowed.
Well, except that provides no screening. If you put it behind the house, you can maybe get some screening from the structure. But if you put it in the side, whether it's a corner lot or a regular lot, there's not going to be any screening at all.
Then
So
it would
how would
still
this-
also have the
Right.
yard setback requirements.
But why would the side in that case be any different from the front?
Well, it wouldn't be, it would just be, because it's a corner lot, the
Well,
side would be
okay,
allowed, right?
But forget the corner lot thing, just look at a regular lot.
Yep.
If you have a regular lot and you have a vehicle, you put it behind the house provides some screening. If you put it on the side or the front, it's the same. There's no screening either way. Right?
Well, yes, potentially, sure, yeah.
That's all I'm
Yeah,
saying.
but the question is, does the law need to be maintained? Does the screening need to be maintained in the law? I think that's what Russ is asking.
that's-
If the answer is no,
Right.
then this is a potential compromise to say, well, if you put it in the back, you don't have to completely screen it. If you put it in the front, then you do have to completely screen it. Just a suggested compromise.
I mean, I think that the law, just going by Section A, is already limiting to, say, one camper. And I think we should all be entitled to have at least one camper on our property.
Or
so-
one boat.
Or one boat, or whatever. I mean, just,
I think the problem is one of the things I think you said, Dean, was the question of trying to prevent a junkyard from happening, right? That's what, I mean, if you have a registered vehicle and it's inspected on that as a camper, such as Russ, we use Russ as an example, I don't see a reason I mean, it's not becoming a junkyard, it's a registered vehicle, or we limit it down to saying, okay, one of these vehicles, as long as it's registered, doesn't need the screening. As far as a corner lot goes, you know, that's a tough thing, because I can use my example, my house down in Florida, I'm on a corner lot, you know, I'm right there, so it definitely, I can understand, you know, with, well, a couple people in the town that have corner lots, that there's issues going on. But I think it's a little over restrictive on trying to do a screening for something, you know, that by today's standards, if it's, I think if it's registered, it's in, and it has a current inspection on it, it's being taken care of, it's being used. It's not, you know, if someone just had one sitting there and then, you know, sitting off on the side for 2 years, and then that might be a whole nother issue.
It seems in the zoning stuff that we've been dealing with for the last 2 years, the flavor of the day is screen everything. We haven't gotten to the point yet of screening the houses so you don't see them either. But if you look at it, everything that we're talking about, parking cars in your yard just about, you got to screen them. If you have a business, you got to screen them.
It is on houses today, because they're saying you can't go and clear a certain part of your property, you gotta have a certain wood in certain areas, there is screening on there.
I'm just saying, it's
The restrictiveness.
it's the flavor of the season. That's what I'm saying.
All right, so what's the pleasure for C? Should we strike out if storage shall be completely screened from roads and neighboring properties, or should we add in or and take out if stored?
I'd take it out.
The or is a better idea, I think, then you're not taking it out. I'm probably oversimplifying this, and I'm not, it's obvious I'm not really that involved in all the zoning stuff that you guys work on all the time. But are we getting ridiculous and penalizing someone because they have a recreational vehicle in their yard? I mean, you know, again, common sense. I mean, you know, I'm a little affluent, so I can have a boat and a camper. They're all registered. I use them.
And I want to brag, and I want to put it out in front of my house.
I don't want, you know, you don't want to put it, you know, but there's a point of reasonableness here.
Yeah, and along those lines, I mean, somebody like Russ who's got a property that's right there on the road is certainly going to be looked at more closely than someone like my own property that's
Right.
2
Nobody
acres
knows.
and back from the road, and nobody knows what the heck I got back there.
Exactly.
You know,
You know, the
it's not-
hamlets are
it's not
certainly
necessarily
more-
screened, maybe in the summer when the leaves are on the trees, but yeah, I think it's going a little far.
Yeah,
So,
I think it's overkill with screening.
so should we end it at unit and scratch out from and if stored?
Yeah,
Yes.
well,
Because we're limiting the number they can have, and we're asking them to park on the rear or the side, right?
Yep.
but
And I think that's pretty
So I agree with much of what you guys are saying, Ian Schrank, sorry. But something's not being used at all. It's been sitting there for literally years, maybe.
yeah.
Why should we allow that to be on the road and unscreened? I mean, to me, that's different. I totally agree. You want to have a boat, you should have a boat. You want a recreational vehicle, you use it a few times a year. I'm fine with that. But if it's some old dumpy thing that's just sitting there,
Exactly.
if it's, you know, maybe could we say if it's not been used, if it's not, has not been used for 6 months, 9 months, 12 months, then it's got to be screened?
Again, I would go back to if it has a current registration.
That's right.
Then I go back to my question about the trailer. I mean, I don't even know what the law is, but the cargo containers, you know, the things
Yeah,
that
that's
They're not
different.
registered.
they're not registered. So, but I would like that to be regulated by this too.
think
That's a
the key.
shipping container.
Right. To me, it's the same eyesore.
They didn't really exist when this was written in the 70s.
Would it be helpful to state in the section to create a new A, the intent of the section. If the intent is to prevent a property from turning into a junkyard or an eyesore, to simply state that as part of this code, so that it gives people a particular direction. Because theoretically, according to this, a person could have a boat on a trailer, parked next to their cargo trailer, parked next to their camping vehicle, all on the side of their house, right? So a person could have up to 5 different things that are parked there.
Plus,
And if
boats
they're all
under
working,
15.
sorry?
Plus boats under 15.
Plus boats, they could have, 100 kayak.
Unlimited.
But the intention being expressed clearly that it's to eliminate this idea of it being a junkyard would set the tone in there, I think. So, and you know, that the idea is that these are operable, if not registered, vehicles or containers. Sorry, the other thing, back to the screening. I like the idea of eliminating it, and I think in particular in Russ's case, where I question that is on a property that is completely screened, where there's enough space in what would be considered the front yard for a person to store something like that, again, thinking about our property, it is completely screened, and most of the usable property is there. If we go to the backyard, we're in our steep and moderate slopes, and we don't want to put something back
In
there.
the woods and
Right,
everything else.
right. So I think there should be some exception or allowance if it is screened. So perhaps it is rear yard of a dwelling unit unless it is completely screened.
So it would say only in the side or rear yard of a dwelling unit unless completely screened from roads and neighboring properties?
Completely screened is very difficult to do.
Well, what he's saying is his is completely screened, so
No,
why
no,
can't they
his
put
is.
stuff in the front?
His is, but Russ can't.
I know, but we're saying that he wouldn't have to do that at all if it's in the side or rear yard, which
It's in
it
the side
which
yard.
it is.
Uh,
And so when we
That
say
is-
unless, so it can be in the front yard if it's completely screened. That's basically what it's saying.
Right.
Because right now, it just would be, we wouldn't let anybody have it in the front yard at all.
As I say, we're screening happy is all I can say.
Yeah, I
Everything's
mean,
being
if we remove it
screened.
completely and then there's no screening, then we're just saying that somebody can't store anything in their front yard.
Yeah.
At
I-
all.
I understand. And other parts of zoning do define what can be stored in the front yard. Not just this section. I think there's another section which describes in the various areas what can be put there.
So Russ, how do you feel about unless?
It's not helping them.
Doesn't hurt them either.
So basically, it would say that it's okay as long as it's in the side or rear. If it's not in the side or rear, it's in the front, then it would have to be screened. That's what it would be basically saying. So take out the and part and put unless.
Well, if I understood you a little while ago, you were going to stop after unit
Yeah.
and delete the rest of it.
That was
Okay?
one suggestion.
Now you're saying unless and
Well-
unless.
The reason is if we delete the rest of it, which we can do, then you're limited to keeping something in the side or rear yard and you can't put anything in your front yard.
Yeah.
So if we add the unless, you can do the side or rear yard unscreened, but if you put it in your front yard, it should be screened.
Yeah, well, I understand the gentleman who's speaking here. His front yard, you can't see the front yard. You go up 9G and all you see is
Yeah,
trees.
yeah,
So he's got a front yard, it's acres of property. And I see no reason why he couldn't put it anywhere he wanted in his property because you can't see it from any other property or the road. So I sympathize with his reasoning on that. And, I mean, what constitutes, I'm not sure, what constitutes the front yard? Is it what, immediately in front of your house? Or if your house is 50 feet back, does the whole 50 feet going up along the front of your property, is that front yard?
Anything that exceeds the front wall of the house. So you take the front wall of the house.
Front door.
Where the front door is and extend it out. If it's in front of that lot line,
No, but I mean, my house, say my house is 50 feet back from the road.
Mhm.
Does that line continue all the way up the length of my property, which is way up the hill? Is that
No,
all
it's
front
from the
yard?
front line of your house.
Or is it just going out,
Yes.
taking the sides of the house and going out to the road?
Yes.
Okay. Well, I have no problem with that because my front yard is my septic system and I'm not gonna park anything on top of that, you know? I put a little hole in it so it can drain onto the road though, overflow.
So what we'll take out is "and if stored" and put "unless." Is that what we're saying?
Rear yard of a dwelling unit unless, I think, and shall be, so it would be
Unless completely.
unless completely screened.
Should there be a caveat here? I'm probably making this worse. But to say registered, currently registered?
Well, you're not allowed to have one.
Because I think there's a
unregistered
distinction
vehicle.
between somebody using something and registering it versus somebody who's got it there, period.
Oh.
And, I mean, it almost implies that it's storage now. It's not.
Well, this would apply to storage or parked. So it's already limiting in A to only one of each type. And I'll just use an example. Let's say I go camping this year and let's say I have a heart attack. So next year I don't go camping, so I don't bother re-registering. Should I be penalized because I'm not using it that year?
Well, you're probably not gonna last long, so it wouldn't matter.
Well, I
anyway.
could still survive. I just may not go camping the next year.
Well, yeah, there's all kinds of scenarios.
Oh.
To me, the trigger is if it's registered, they're using it at some point. If it's not, then you question if it's just storage there, but whatever.
You're gonna have to add a motor home, because that's not covered here. In that listing.
Well, wouldn't the
Camping
recreation,
vehicle is not a motor home.
So I'll say camping vehicle or motorhome. How about that?
Yeah, and it's just left out. Now, if you wanna put in, as he was saying, shipping container, which is not even mentioned, that's something else.
this is taking on a life of its own.
Well, I mean, that could be classified as a cargo trailer. I mean, even though it's not a movable trailer, it could be.
Okay.
I mean,
I'm-
people rent those tractor trailers with
Oh,
the
yeah.
wheels
And without the wheels.
and
both
without.
ways. Yeah, I just bring it up so we resolve it, that's all.
So we can say cargo or storage trailer.
As I understand the word, means with the wheels.
Yes.
The tractor is the front part with the engine, the trailer is the bed with the wheels, and the container is the box that sits on top of the
Right.
trailer. And I thought, we have cargo trailer here.
So
we don't have the
cargo,
container.
storage, or trailer.
Yeah, a container, I guess. It'd just be the cargo trailer, container, or camping vehicle, motorhome.
Cargo trailer or
you
container.
say, or cargo container, maybe that's clearer, cargo
Yeah.
container.
And then anything in D, E, or F.
I hope not.
No.
And then Ray wants to add in except in case of emergency.
Yeah.
All right, that's fine.
Define emergency.
Oh, God. Common sense. Is that an emergency?
Exactly. It's a personal emergency.
Power outage and all that kind of stuff.
Your mother-in-law comes to stay.
Oh, you got.
Is that an emergency?
It is if I'm going to kill her.
I've run out of them, so I
Or
don't
she's
have
gonna
that
kill me.
problem.
All right. So did we beat this up enough for a very small one-page section that we didn't touch? Seeing that it's 10 after 9, I would say that we'll continue on with the rest of the sections that we didn't do today at our next meeting, which would be December
5th?
yeah, 3rd, 5th, whatever it was there.
December 5th, I
Fourth
think,
and
is a
fifth.
Thursday.
Thursday the 5th.
Fifth.
And then just going forward, the 5th, and it would be the 19th. Are we going to still have a meeting on the 19th, or? I mean, it's the week before Christmas, but what's the
We're
pleasure?
We're gonna have other meetings for the board, just so you know. We have the annual meeting. We're gonna have to have at the end of the, I'm trying to find out what date that fits so that we can process checks and I can sign them.
Well, it would be Monday the 30th, wouldn't it?
Got to be sure the bookkeeper is going to be there to be able to go through them after we have the town board meeting. So we got to get the information from the employees to get the vouchers in. So, I mean, it's a timing problem. So the end of the month around Christmas time is going to be challenging.
Yeah, but we usually do it either the last week of the month. Not,
I know,
We
but
don't usually
we-
do it before Christmas.
No, but I'm just saying, people got to get me stuff that we're going to have to do.
Yeah, it would have to be the 27th or the 30th, and if we did it on the 30th, would they have time to go through it?
That's what
on
I'm
the
working on,
31st?
yeah.
I'm, even, I'm,
And we got
I'm just
paid.
talking about when we're having a meeting. Are we going to have it
Yeah.
on the 19th or not?
Yeah.
So
Oh, that
that's
one, yeah.
so I'm sure we're not going to have a meeting on the 19th. That's why I'm asking.
Yeah.
Are there no other meetings on the 19th? Are we going to still have this? So think about it. We'll talk about it on the 5th. How about that?
Yeah.
All right. All right. So it's 9:10. Thanks
What's
for coming.
next times? Are we going through ones that haven't been revised now?
Yeah, unless we have to do the short-term rental again.
Yeah. Well, that's up to you guys.
I wasn't prepared for it.
It's just.
Actually, that's before the town board meeting.
Okay, so I make a motion to adjourn the workshop.
Second.
All in favor?
Aye.
Aye, motion carried.
So what I'm saying, if we go through short-term rentals next time and we get it nailed down, I can introduce it officially at the next board meeting and then have a public hearing in January.